And this is also for Miriam, actually.
We're live. Let me just welcome everyone. Welcome back, everyone. It is still Thursday, February 26th at 1:12 PM. This is the Committee on General and Housing. Okay, it is. We are continuing our discussion and we have a possible vote on 772. We had a draft and that draft has been edited and several additions have been made to reflect discussions to date. Council, do you want to quickly go over those?
Yes. Did you want to get to that question first?
Oh, right.
Oh, I'm sorry. Go ahead.
I guess the Mark question is the ADA coordinator bill being discussed at all this week? No, okay.
Is that because the ADA coordinator bill,
It was supposed to be this afternoon.
Katie McLean was gonna do a walkthrough.
is there a reason that can't happen tomorrow for the walkthrough?
She's out.
Oh, okay. Okay, so that's gonna happen. I believe it should happen, and I think it should happen immediately upon our return. Okay, great, all right.
And just quickly, so there's still time to work on that, right?
Yeah.
Well, also, let's see how, by the way, does Katie have any time this afternoon? Could you just check?
Thank you so much.
Yeah. The reason I say is I'd like to open up I'd like to have the 772.
Yeah.
Some minor changes, and then I'd like to have discussion and a vote. And I think, she's not. Okay,
Okay.
all right, so then it's going to be
First
immediately.
thing.
All right, first thing. I think that bill can get out of here and get to approach in time.
My other question is for Cameron, and Cameron knows what I'm talking about. It was the discussion from the end of where you were gone.
Yeah,
But it had to do with current law with regards to tenant remedies for inhabitable dwellings. So if you could just explain what the current law says.
Yes, ma'am. So. Well, I just admitted someone. Is there not? Okay. Yes, I'd be happy to. For the record, Cameron Wood, Office of Legislative Counsel. So typically, I'm gonna pull up the current statutory section regarding habitability and tenant remedies. Okay, so if the landlord fails to comply with the landlord's obligations for habitability, so as you all remember, there is a specific section about the landlord's obligation and warranty of habitability for the premises. That section specifically only references to heat and water. But there is the Division of Fire Safety residential rules that go into much more detail about the code requirements for habitability of a residential dwelling unit. So if the landlord fails to comply, and after actual notice of the non-compliance from the tenant, a governmental entity or qualified independent inspector. In this case, at this point, that would be the Division of Fire Safety, because you've gotten rid of the municipal inspectors and put that jurisdiction under the Division of Fire Safety. If the landlord fails to make repairs within a reasonable time and the non-compliance materially affects the health and safety, the tenant may withhold payment of rent, obtain injunctive relief, recover damages, cost reasonable attorney's fees, and terminate the rental agreement on reasonable notice. I have not done exhaustive search of Vermont's court cases in this regard. So there's kind of a lot of questions around some of those things. One was asked earlier, who determines what a reasonable time is? The courts would, and I'm not aware off the top of my head that they have given some sort of hard line rule of a reasonable time means, pick, 10 days. I'm not aware of that, but. And the discussion that I was having, Rep. Burrows, if I may, the question was about, what if a unit is, uninhabitable? And, I would look at a few things, if the landlord fails to comply with the landlord's obligations, and, a question would be, first question I would have is, what is the issue? And was it within the control of the landlord, for starters? And then you would need to look at, is the landlord failing to make the repairs within a reasonable time? Within that time, the tenant can withhold payment of rent. They could seek injunctive relief, so they could go to court and try to seek an order from the court mandating that the landlord repair whatever the habitability issue is.
That's the injunctive relief.
Yes, sir. The tenant could seek damages from the landlord. So if the habitability issue somehow led to some sort of damage to the tenant, so either, damage to the individual themselves, they were injured as a result of the uninhabitability issue, or there was some sort of damage to their property as a result.
How about if they were just forced to rent something else?
I don't know the answer to that. It is not here. So you would have to demonstrate that you had to move somewhere else and you were damaged to that effect. I think it is possible. I don't know what the courts have determined. I think, the discussion was, to what extent is this within the control of the landlord? Was the landlord aware of it and, chose to ignore it and not fix it versus something that may have occurred, kind of,
Like the flooding?
under the acts of God type situation, that may not have been known to the landlord, but, I would be looking at it as, what was the occurrence? How long did it take the landlord to react? Did the landlord sit on it and do nothing such that your apartment was flooding and, didn't have a plumber come out, didn't, call someone to come fix the issue and, you're telling them, hey, there's clearly, water building up in the roof and the landlord does nothing about it. And then a week goes by and then, it bursts and floods your apartment. You probably.
I think those are, in
significant
fact,
case, right?
exactly the factual. From my life, in my former life as a legal aid lawyer, those are the factual demonstrations. You have to give a really good notice and then show that it's uninhabitable and then we look for a reasonable place to live.
To answer the question, I don't know because I would need to spend some time doing some analysis of what the cases have determined if somebody has asked for or sought damages that included, recovering costs of some sort of additional relocation expense or costs of additional dwelling. You could put that in there and you could specify that if it was that those damages include the cost of relocation, and then you would be signaling to the court that we're intending that to be included. I am personally I can't answer that immediate question at this point, but I will do the kind of legal analysis and you may be able to find other individuals, possibly even in the room. Who may know the answer.
Okay, go ahead. Jean, I know who you're referring to. Yeah, did you have another question, Elizabeth?
Oh, no, that was it for now.
Okay. So what I'd like to do is go ahead and go through. Oh, did you have a question?
I just had a question. So in other words, it sounds like this Looking at all of that language, have we not now added
Yes. This is
much more
addition-
specific definitions
Well,
of
it's the
what
defense section.
inhabitability?
No, there's the habitability section, which anybody can use at any time. And then there's this other section that we've added is a defense. Once you've been a defense to an ejectment.
For ejectment action,
Right.
okay. Um,
This section is what you're.
So now are we deciding if we, no,
So what are the changes?
Okay, yes, I will, let me walk through the amendments that you have. So this is draft 3.1, strike all amendment to 772. The first change I'm going to get to is on page 4. Where I've added some language here that states that if conducting a background or credit check on an applicant, the landlord or the landlord's agent shall provide a copy of the results of the background or credit check to the applicant. Pause there, just make sure I've captured what the desire was.
Okay,
Page 5.
don't have a question.
Does. Gotta get into this point. I'm just referring to previous conversations about sometimes that background check is just calling previous landlords, things like that, and it's not actually necessarily pulling a
Company.
neat, clean background check that you can hand them on paper. It's actually just calling of other people.
right, but if you're gonna charge
So you
somebody,
have to like write what people said down and then hand it to them, like write down what people told you? Or is this like,
let's just check.
that's references?
That's reference.
Okay, so, okay, perfect, good, move on.
Page 5 in the.
Yes,
I mean, we could you indicate that if payment was received for background, then the results will be, after the results are shared?
You could further condition for, if you wanted to say if they're charging for a background. Right now, it's just if they conduct one.
Yeah.
You could change it to say if
Conduction.
charging. If you're charging for them, then you
Yeah.
have to provide the results. You could change that if you want.
so it would say conduct and charge.
Or just
I would just say. if you're
charging,
Okay,
if there is a charge for background credit.
all right,
I mean, in
Right.
theory, that would also somewhat ensure that if you're going to charge someone for one, you're going to do one if you have to provide them with the results of it, as opposed to charging them
Right.
and then not doing one.
all right. Committee,
I think that this way it benefits the person who's
I'm seeing
paying for it. If we're gonna allow for that as part of the process, then
okay.
they should
so,
benefit.
Called it criminal background check, no, that's what,
Well,
and that's what they're called.
Mm.
It's creditworthiness and criminal background check, it's not references.
sure, I'm happy with adding criminal.
Background just encompasses all of it.
I don't conduct them, so I don't know if there is I don't imagine there's a statutory form of art here, so my legal opinion to you is background check is fine. don't know that
I
you
think
need
it's
to
all right.
specify
All encompasses.
background
I
check,
agree.
but
Okay,
And if another body thinks it needs to be criminal, they'll put it in.
I think criminal is fine because
Oh,
the,
you want criminal?
yeah, I would like to say criminal.
Okay.
Let's-
We don't, it doesn't look like we want criminal. Some people. Don't cares.
Isn't that part of the back?
Look at your social media posts, are they gonna look at it? But that's not, that's not.
Background check.
I think we're getting a little weedy.
Yes, I was getting a little
That was
weedy.
your fault.
I apologize.
Joe
Let's,
loves to get weedy.
not a bad thing to have if you're charging for one, but.
okay, let's go. Next,
so I'm not making any changes other than saying charging.
Right.
Okay, moving to page 5. Under the subdivision 2. This is under those circumstances where the landlord is terminating the tenancy, the landlord shall return 1/2 of the security deposit and There was a request for a clarification to ensure that the landlord shall return 1/2 of the security deposit, subject to any deductions authorized by subsection B, which is the section that authorizes the landlord to deduct for non-payments. Still requires the written statement itemizing the deduction, just so that's more of a clarification piece. The next change is going.
Ask you about that section. So this is something that like, it's not an agreement between the tenant and the landlord, like the tenant makes the request.
You all asked in the last amendment to have it at the request of the tenant.
Okay,
So it's two conditions have to be met. It has to be a termination under one of those subdivisions. And the tenant has to request it.
Okay. All right,
The next change is on page 6. Is from the retaliation provision. This is just, it was a change recommended by our editors and I made it. And so I just wanted everyone to be aware and not think I was sneaking things by you. On line 14, it's just restructuring the sentence to say that the tenant has taken any legal action authorized by law. So it's the same fact that just. The next change. Pardon me, I did not write them down, so. Next change is in the trespass section.
page what?
I'm giving it page 22. Or excuse me, the change is actually on page 23. So I spoke with our legal counsel on the judiciary team. And we felt that the provision that I had added in was somewhat unnecessary, so I removed it. So
Purpose?
no, the purpose remains the same.
Yeah,
What this is doing is I had it to say that also, if somebody's been ejected, then
yeah,
the trespass order would apply. And we felt that your intention was to ensure that if somebody's been ejected and they come back and they're conducting illegal activity or they're, violating lease terms of other individuals, that was kind of one of the scenarios I remember hearing was you get ejected, but then you just go into somebody else's apartment and you're dealing drugs out of that apartment this time. Those are really already covered under the B and C.
okay,
If you come back and you're breaking the law or you're breaking the lease, then you can be given a trespass under this section. And there was some concern about if you just say you've been ejected and you're not allowed back, you're not violating the law and you're not breaking anyone's lease, that may be too overbroad.
right,
So we felt the B and C was covering what you want.
okay, all right.
Okay.
This was your editors, the judicial.
And in talking with the judiciary team.
Okay,
Yes, sir.
right,
Okay.
okay.
So the next change is on page 25. And I just wanted to flag something for you all, similar to the conversation we were having. So the request that I had after I left was to add a default judgment here. If the court of so this is, we mentioned this is regarding the confidential nature of the records. So it says that if the court of jurisdiction in an ejectment case issues a final or default judgment after an evidentiary hearing in favor of the landlord, where a finding has been made of non-payment of rent or breach of a rental agreement, the court shall remove the confidentiality. So I added for default there. One thing I'm not quite clear on, and I would ask the judiciary representative if the individual were able to answer is there's the condition of saying after an evidentiary hearing. So I see that as kind of a policy decision for you all. If an individual goes in and files the complaint and then the defendant never participates and they get a default judgment, do you want that to remain confidential? Do you want there to be a requirement of the evidentiary hearing? If so, leave it alone.
I just want to know, does the language as you've written it intend to say that the confidentiality is lifted if there is a judgment, either after a evidentiary hearing or just a default judgment,
So
where there's no evidentiary hearing because the tenant leaves or for any number of reasons.
I would read this to say that the final or default judgment after an evidentiary hearing, so it would require an evidentiary hearing. And so if someone came in, filed the complaint, and the defendant never participated and the plaintiff received a default judgment against the individual and there was never a hearing, then it would remain confidential.
I think the intention was that the confidentiality would lift upon any judgment.
Then I would remove the second highlight and just say final judgment, final or default judgment in favor based on those two conditions. A or B.
All right,
I would remove that. Just say. The ejectment case issued a final or default judgment in favor of the landlord where the finding has been made of non-payment of rent or breach of the rental.
right.
Okay. There's one other change. Page 32. 32. This is in the landlord and tenant education technical assistance program. And it's where CDOEO is developing this curriculum.
Yeah.
It had in there that CDOEO would work with specific partners, it listed them.
Yeah.
And there was a request to remove it. This language would allow CDOEO, they can work with whomever they want.
Right.
It would be entirely at their discretion, so it was just removing language, so. For the landlords, they shall develop the curriculum.
Yeah.
Who they.
So this just gives them
partner with,
discretion
work
who
with.
they want to work with, right? Okay. Are those all the changes?
Those are all the changes that I've made since.
To this draft, right.
Thank you.
So at this point, what I think I'd like to do, right, is I'd like to open this for discussion.
The two changes that we
And come
discussed.
back,
Well,
right.
I'm not going anywhere.
You can do it, you can do it
I
here.
can do it on the fly. All right.
He's that good.
So I, at this point, would very much like to invite the committee to discuss this draft and say what they want to say, and then after discussion, we'll have a vote. Yes,
I'll kick us off. Everyone to not, I guess. Earlier, when you both stepped out, I gave a mini of this, but, you know, I have spent, several years diving into this line of policy and, Representative Parsons and I have served on the task force committee, which had a report, and I feel like it's important to follow through on the work that we did on the report. We spent a lot of time listening, learning, and we're continuing that work. This has not been easy. This has been one of the hardest bills that I've worked on in my time in the legislature. There are things in this bill that I don't love. There are things I do love. But it has been made abundantly clear to me that the status quo is not working for people. And as we continue to work on different tools addressing the housing crisis in Vermont, which a new poll showed, 82% of Vermonters are wanting the legislature to act on housing related issues, and it's still a #1 issue. I think that landlord-tenant relationships is a huge part of that, and I will be voting to support this bill. And again, it still has a road to go through. And I want to thank the committee for incredibly intense work and great detail and dedication to get us to this point with, what was it, 5 or 6 landlord tenant bills that have been on our wall, working to give and get. And I think that this bill achieves things for folks that they've been asking for, and I am going to support this bill, but that doesn't mean that everything in the bill I love. And that's kind of where I'm at. So I will be voting to support the bill and just want to thank the committee for their dedication and work on this to get us here.
Thank you. Tom?
So we knew going into this that it was not going to be simple and that there wasn't going to be conclusions that would make anybody giddy. I feel like we have provided some protections for people, landlords and tenants who are doing their best to do things right. And I think that we've upped the expectation of responsibility on all involved. Any one of us at the table would have written the bill a little bit differently. I think there's, at this point, we have to give time for this to get together committees, so. You know, I'll give it a C plus, maybe a B minus, and I think that I can move it on that basis, but I think there will be opportunity in the next session, there will be opportunity in their committees, they will have some perspectives that we might not have at this table, so I'm in favor of the bill as it stands.
Comments? Thank you very much, Tom. Other comments by this wonderful committee? Yes.
I think I just want to take a second and thank the committee. I think starting last year and this year, we've created this foundation where we're willing to take on really difficult bills that we know are going to have hard conversations. And kind of, going into it, we've braced before the storm, but I just really appreciate, I feel we've asked a lot of questions and that's what we're here to do. And I agree, it's actually one of my biggest pet peeves is that we're constantly hearing, you can't let perfect be the enemy of the good. But I think we've just continuously heard that the status quo is not working. I don't think this is the end of the conversation. I think there's we're gonna have to make corrections. But again, I just wanted to take a moment and thank the rest of the committee for their dedication to kind of working in the uncomfortable.
Other comments? Yes.
I'll say, I want to say yes, thank you to the committee for taking this up and having and engaging in this conversation. I feel like the conversation didn't go where it needed to go. I thought we received an abundance of written testimony that was not acknowledged in this room. And that was, in my opinion, disregarded. I also feel like we failed to acknowledge the inherent systemic inequities that exist as a result of systemic oppression inherently, which is why we are told we go through things, we learn, we do better, we get put in positions where we can make the changes necessary so that those cycles do not repeat themselves. I don't feel like we met the mark here. I feel like we didn't discuss the balance between power and privilege that what is held. And I feel like this was not a conversation which was supposed to be, I feel like it was supposed to be around the evictions, eviction procedures and the creation of positive rental. So I just feel like if I would support this bill if it were an act relating to rental agreements and the creation of the positive rental payment and creating a pilot program. The eviction procedures portion, I feel like we heard an abundance of testimony from the powers that be, the powers that have served in its roles for several years, decades, they tell us. People create bias and lens. And I would like to say, I thank you for listening to my rant this morning, and I apologize because I don't live there. I am housed and I am healed. However, that's why I go through this, so that other people don't have to. And when I hear conversations that will put people in the same positions that we worked so hard to overcome, it kind of breaks my heart a little bit, and it's infuriating as I will tell you, I take in people. I help them pack their boxes when they have to move. And I said, you know what? Let me try to help so we can do something. What I would have loved to have more of that landlord-tenant relationship. Where was the relationship building in this conversation? That part I didn't hear. What we heard was this side and this side. What we didn't hear was a balance and a way to mitigate and mediate and build stronger relationships so we can have more improved societal norms, which I feel like as a body, as the government, which I had to go and look up. I was like, what is the role of the government? What is my role as a legislator? So I'm like, am I gaslighting myself here to think that I'm wrong in my thought process? And we are here, we are responsible for making the laws that govern the state. And that vary dependingly, but we are here to provide that balance. And I just feel like I feel like we didn't do that. I feel like we didn't give it teeth. I feel like we've had diligent conversation. I will say that conversation's been there, but it hasn't been what it needed to be. And it hasn't focused on the things that will move our communities in a way where we will see change and impact for benefit on either party. Full disclosure, I don't see either party benefiting from this. So I would like to say it is more landlord heavy in my opinion, but I don't really see them benefiting either. Like no one, and I think we didn't discuss the word compromise because I think we approach this from a lens of compromises, nobody gets what they want. No, compromises, how do we get folks as close to what they want as possible? And I feel like we approach this conversation from the lens of going in opposite directions instead of trying to meet in the middle. And that's why we got where we are. So I'm grateful that the conversation got here. And I don't feel like it's where it needs to be. And for that, I'm a no.
Thank you. Other people? Any other people wish to comment? Good.
Did we change the, notice time?
What's the,
Six.
is mailing
6
5 or 3?
3.
It's 5 at the moment.
It was 5 for mailing.
Right.
3.
Yeah.
The presumption is that 5 days for mailing, email, or posting. That didn't change it. So it is 3, but it's going to 5.
Right, for the mailing part. But we were changing the notice.
I thought I had to leave right in the middle
Yeah,
of this. I thought
sorry.
we were moving towards 3, but it was a divided view.
I'm sorry, we did decide, I think we need to make it 3.
We did?
No, the mailing is 5.
No, sorry.
Mailing
So
is
then
5.
what, so then it's okay the way it is?
No, it'd be right now, we changed it to a 10-day notice with
Right.
5 days of mailing.
Right,
We're gonna change it to a 3-day notice with 5 days of mailing.
Oh, I thought it was gonna be 3 and 10.
okay, I thought it was 3 and 10. Well, I'm not,
I thought that's just me, I could be wrong. I think you wanted 3 and 5, yes.
Before, what I'd like, yes,
Just. Would you like me to change anything as it relates to the conversation that you were just having?
in other words, originally, right now, under existing law, the mailing is deemed received after 3 days. Right now, under existing law. I will take responsibility for this. I put it 5 just because I worry about the mail these days.
right,
I have to say that I was comfortable moving it back to 3, just personally, if we wanted to. I don't have strong feelings about this. But I don't want to hold this up. The current draft is 5. I think what I'd like to do, if it's all right with people, first of all, is hear from people about the whole bill, that aside, and we can discuss whether we want to make that one change.
It's good.
People, the reason I was, now, when someone is in a situation where they're going to be ejected because they've either damaged the apartment or they are not paying rent, or then they know if someone is going to be ejected because of action by the landlord, such as non-renewal of the lease or conversion of the building to some other use, the landlord, after they give them whatever this 3, 5, or whatever notice is, it doesn't matter because they have another 3 months after that. There's 90 days notice. So for me, that's why I don't find that these 2 days makes that much of a difference. But I guess let's move on, and I'd like to know if there are other people who'd like to comment on the legislation as a whole. Yes.
So I'm hearing loud and clear from advocates that the shortened periods are gonna put a real stress on tenants who are struggling. And we have heard continuously that small landlords are facing similar struggles, similar challenges, not to the degree of necessarily being out on the street, but having enough pressures that it could cause them to get out of the business of renting spaces, which is also undesirable. It's also undesirable to, anybody to, go without because they have higher costs than what they make. I recognize that the imbalance is very different, that the level of like who's in the most vulnerable position is vastly different. For me, the comfort was in keeping the access to assistance. And I'm putting a lot of good faith into education before this becomes law, into what resources are out there, the rights and obligations, and buckets of money for well-intentioned, good tenants who should not fall through the cracks because 30% of your income is no longer reasonable to expect to spend on housing. When the other 70% costs are actually also higher. Like there's just, it's very hard to remain whole if your housing is up and your health insurance and your food assistance is gone. I am nervous about doing this change while we are also losing a lot of federal supports for people who are vulnerable. That is going to be our responsibility as a state to take into account that we are now putting folks at risk. I hope that people will be better actors. I truly, truly do. I really hope I don't regret this vote. But I will vote yes, as long as there's a serious rental arrears program in place to support people. And backing up legal representation.
Yes, Debbie.
The reason I was advocating for a 3-day for non-payment of rent, a 3-day termination notice is because the faster that gets into the hands of the tenant, the faster they'll be able to find a remedy. And they can take it to agencies. They can take it to, we've been through this, churches, there's other organizations, they can take it. And we've expanded, we had 30 days for, if you want to call it negotiation or mediation, to try to figure things out between the tenant and the landlord. We've gone to 60 days, so we have a longer period that we can work things out. Remember, we did the 60, changed it back to 60. So I think it's important for the tenants to get that in their hands. We added the 5 days extra for the mailing part. So you're actually looking at a total of like 8 days, so we can, whatever way the tenant want, we can email it. I mean, the landlord is gonna get this notice to them because they know they can get help when they have that in their hands. It doesn't mean you have to receive it in the mail, but if the mail is like a backup and you can email this, we can have it served by sheriff, we can, all the things that we have in here. So that's why I was advocating for non-payment of rent, doing a 3-day termination notice. To get that in their hands and they can go out. We had a memo from NECA, 48 hours will tell you how much we can help.
Can we hear how other folks feel about the bill first? Because I think we're gonna go back to that piece, but we're still working on hearing. Mary, I think was.
Yeah, let's see how
This-
people feel about the whole
This
bill.
is such a difficult bill. And I've heard from landlords and tenants. I know good landlords and good tenants, and I know the bad landlords and the bad tenants. I kind of agree with a lot of what Saudi said, and also what Leonora said. I think this is more advantageous for the landlord than it is for the tenant, especially today when, I mean, you can't find an apartment anywhere. In Rutland alone, there's 120 duplexes unrented. That's a lot. This hasn't been just a housing problem since COVID. This has been before COVID, and we should have been doing, but hindsight's a great thing. I have a hard time thinking about a family that's being evicted and can't find a place to live and is put out on the street. I really have a hard time with that. When I worked in the state's attorney's office and when children were living in motels and hotels, it was heart-wrenching, and everybody knew the address of the hotels. They knew these kids were playing in the parking lots. That's not a way for a child to grow up in. I will, with some reluctancy, vote yes, only because I think something is better than nothing. And I'm sure when it goes to these other committees, they're gonna look at it and they're gonna change things all around. I have a strong suspicion that this bill will not be passed this year. I think we put a ton of time into this bill. I don't think we can hear from any more witnesses because now it's becoming so complicated when it should be a little more simple. So.
Thank you,
that's
Mary.
My opinion.
Yeah. Anybody else want to make any general comments?
Oh,
No, go ahead.
so Thank you. I'm. I'll just reiterate what's been said 1,000 times during this process, but like everything in this bill is gonna get you to want to vote for it or say, I can't do that. And there's certainly things in this bill that if it was a standalone bill, I wouldn't be voting for. But that being said, it's, you know, we got 33 pages bound to happen. So my process is literally, if I were to talk to this in front of the 4,400 people I represent, I think the majority of them would say that's better than the system we have now. And that's how I pretty much vote on everything, so.
Elizabeth, you had your hand up.
I was gonna say that, I agree that there are some good, things in this bill. And, I don't think that those in any way outweigh, the scenarios that I see, being set up for people losing their homes and families being separated from each other, and we do not have a system set up to support people who have lost their homes. We know that. But the outcome of that is increasingly acute, really month over month, year over year. And we have done nothing to address that massive and glaring problem, and certainly not through this bill. And I see it kind of nibbling around the edges for landlords, and I see it really undermining a lot of dignity of tenants. We have, there hasn't been enough asking of who is being left out of this bill. There hasn't been enough asking of who has been damaged already and how. There hasn't been enough, we have taken testimony, but my mind, I don't see it as a landlord tenant bill. I see it as a landlord bill. And so I would be a no on this bill.
Is there anyone else who would like to comment on this? My inclination is at this point, for the bill as it is, call for a vote. Yes,
I make one comment on language.
please.
As we were sitting here, one of the discussed possible changes was about the background check or the credit check.
Yeah.
Providing the copy to the individual, and it currently says if you conduct one, and it was talked about changing to charging one. And after that sat in my head for a minute, I would potentially not make that change. Because I think my understanding of the intent is that you want the tenant or the applicant to have a copy of that.
Yeah.
And my thought is whether the landlord charges them for it or not. So if you change it to charging, then if I don't charge you, I don't have to give you a copy. And the applicant may want the copy, they may want to see, you've done a background check and I may want to see what you found, because I may want to test, it may not be the right word, but identify errors if there are some.
Okay.
So my recommendation would be just to leave it as it is.
Okay.
If the landlord conducts the background check, whether you're gonna charge for it or not, if you're conducting one, you're giving a copy of it to the applicant. So that would be my proposal. You all then can tell me if they feel that's not meeting your expectation.
I was gonna look towards the person who doesn't charge for all of them. And would have to
Please.
then give everybody.
Please, I'm just pointing it out because I
Credit check or the
wasn't sure
check.
that that was the intent of
That-
what we were thinking.
Sorry to jump in, but it seems odd to have to give something to somebody that they never paid anything. Do you give people a
Am I
report?
being called upon?
Just asking.
Go ahead.
Chris Donnelly with Champlain Housing Trust.
I'll believe
We
that.
received over 3,000 applications in here, we do a lot of credit checks, background checks, what have you, we don't provide them. It would be a huge expense and administrative nightmare to process all of that, so we just add to our costs. And we don't charge. Because we want to have a low barrier to access. If something comes up and we then use that information to say
3 days
No.
on Rosemary.
then we provide the reason why. And people have a chance to review.
Thank you.
Okay,
Can I ask,
I'd like to then stay with Charles.
can I ask a question? How would the committee feel if we, final change, one more change, how would the committee feel if we moved to the 3-day?
Mailing is.
Mailing is,
Okay.
I
You don't
thought
wanna
that's
do
what
it?
you,
3 days,
isn't that what you wanted?
No, it's really not what you.
Oh,
no.
okay.
it's,
So,
it has to do with
It has to do with the 10 days.
the, for non-payment of rent, determination notice. Have it be a 3 days. Mailing, you wanted to keep it at 5,
right,
we do
Uh,
5.
Gotcha.
The only
So
thing,
we're
yeah,
looking at 8 to 9 days.
like, okay,
It just gets it in their hand faster so they can get.
I would like, do I have, I'm gonna make a motion.
no, I don't, I'll do it.
Yeah, go ahead.
What's the latest draft?
It will be 4.1.
I make a motion to approve draft 4.1 of H772. Do I have a second?
No. You have a question?
Oh,
That's allowable at this time?
Sure.
Do we have a copy of 4.1 on our website?
Do not at this moment, but I can get you one.
yeah,
Document.
I'm sorry, I thought we had the copy.
No, we don't. We have,
Yeah, my
we
bad.
know what it is, but, yeah.
So I will walk through very quickly what I did.
I kind of wanted to call it just.
Oh, sure.
On page 3, I changed this to charging, so if charging for a background check, the landlord or the landlord's agent shall provide a copy.
Or go down there and tell them I'm gonna be late and they've got that.
Towards the end in the section.
Actually, I think you should go down and tell them it's a committee
I
session
changed
until it's
it
lost.
to.
After you're doing what, you do that first, okay. What? Okay, all right.
Simply state that it loses its confidential status here. If the court of jurisdiction, line 11, in an ejectment case issues a final or default judgment in favor of the landlord where a finding has been made of non-payment of rent or breach of rental agreement, the court shall remove confidential. Those are the only changes from draft 3.1. And I will get you a copy. I'm sending a copy to the committee assistant as we speak.
Okay. Do we have a second to the bill? Fair person.
Is there a second?
Second.
Okay.
Okay. The bill is on it's on the floor. And we're about to call for a vote. Do we need,
I think people just need a few minutes to read through.
right, I'm gonna say that, yeah. So the bill is now posted and what I do want to say something,
Oh.
if I might. Mostly, I just want to say I really feel so fortunate to be a member of this committee, period. And it's really been one of the best experiences of my life. And this very difficult debate has not only not changed that, but enhanced it. Thank you. That's what I have to say. And individual statements of people have done nothing but enhance that feeling, and the votes, your votes, it's not a matter that affects that in the slightest. That's all. Everything else has been said. I do want to say now, going from the sublime to the ridiculous, I do want to say, I do think that if a landlord provides notice to a tenant in non-payment of rent, and they're in a relationship where the tenant can go get help and the landlord's encouraging it, they will right away as soon as they receive the notice, without waiting for any time, 2 days, 3 days, 5 days. They'll just use it. But I understand the concern. At this point, what? Oh, sorry.
No, sorry.
At this point, we want to wait a few minutes?
Joe?
Well, I haven't seen this draft that we're moving forward, so yes, I would like to.
Okay.
Okay,
This is 3.1 is what's.
it's 4.1.
It's very sweet.
Oh, okay.
What you sent in your back.
Yeah, my second.
I thought it was Friday. It's not.
It is supposed to come in tomorrow.
Yeah, no, I know.
Chair, while I'm waiting for the, I'm waiting for the bill to come to me, but, in the interim, I asked earlier when you had stepped out, or made a statement, now I'm inquiring, I'm changing my statement to a question. Around, why, is there a reason or some legal precedent as to why landlords are not treated as business owners? Or like, because there would be provisions by default, there would be requirements by default. So I'm confused if we're talking about in the business of being a landlord or charging money or contractual agreement, why are there not consumer protections around those types of things?
I think there are, but counsel, do you want to comment on that? I mean, all the fair business practice laws apply to landlord, to my knowledge.
It would be a question I would pose to the Attorney General of their interpretation of it. They are, I mean, you're operating in a commercial capacity, sure. And you may very well register as an organization. So the landlord may very well be a registered LLC, for example. So they're treated as a commercial entity in that sense. And the AG's office may very well say that they feel that it comes under the Consumer Protection Act. One thing that is in the bill is to very clearly articulate that, you know, the violation of the fees provision would be an unfair practice in commerce.
I think.
Are we at this point?
Clerk commends.
I think at this point, are we ready for the?
Good.
All right. Mary, would you call the roll?
Please. Representative Bartley,
Oh my God, I'm so sorry. Yes. I'm so sorry.
Representative Burrows.
No.
Representative Charlton,
Yes.
Representative Dodge.
Yes.
Representative Dalton. Debbie, okay.
It's gonna come back to us eventually. And there's a lot I do not agree with this. But I will vote yes to get it out in here. And then hopefully we can fix it when it comes back to us.
We got a lot of work ahead of us. Please continue.
Representative Howard. I have to. vote. Representative Krasnow,
Yes.
Representative Lamont,
No,
Representative Parsons,
Yes.
Representative Tezo,
Yes.
excuse me. Representative Mahaly,
Yes.
H 3-0.
Thank you, everyone. I will be the reporter of the bill for now. I will now depart in order to go down to appropriations and defend the money that we have put in the bill, and I will indicate the rental arrears as top priority.
Thank
Are
you.
we on a break now?
We're on a break, and
What's that?
I don't know if we have anything else on the agenda.
No, but I
Okay.
think we need a break.
We need a break. We are now offline.